From binary code to legal program simulation, towards a mathematical model of legal intelligence. Abstract. Legal reasoning is usually described as the application of law to facts, producing a binary outcome, legal or illegal. This paper argues that the binary distinction describes only the final compression of a much longer cognitive process. Before conduct can be marked as lawful or unlawful, a factual event must first be transformed into a legal event through the selection of a legal program. Building on Niklas Luhmann's distinction between legal code and legal programs, this paper develops a mathematical model of legal intelligence. It introduces the zero-state, legal interpretation, legal valence, competing program systems, and the judicial function as elements of a broader computational architecture of legal reasoning. The central claim is that legal expertise begins before legal rules are applied. It begins with identifying which legal program has interpretive competence over a factual event. On this model, artificial intelligence should not be understood primarily as a tool for legal document generation, but as a means of simulating, comparing, and testing legal programs. The future of legal AI may therefore lie not in faster drafting, but in legal program simulation, the computational exploration of how reality becomes capable of receiving legal meaning. 1. The classical binary model. The starting point of this inquiry is not artificial intelligence, but a much older question arising from systems theory. Niklas Luhmann famously described law as operating through a binary distinction: legal, illegal, legal, illegal, legal, illegal. Within systems theory, this distinction is referred to as the legal code. For the purposes of this paper, however, it is useful to distinguish between the sociological meaning of code and its computational meaning. In Luhmann's theory, the code functions as the binary distinction through which the legal system communicates. In computational architecture, however, a code normally refers to something different, a structured sequence of executable operations capable of transforming an input into an output. The binary distinction, legal, illegal, legal, illegal, legal, illegal, does not itself perform such a transformation. It merely represents the possible end states of legal classification. This distinction becomes important because it changes the question we are trying to answer, rather than asking. How does law distinguish between legal and illegal? We ask a computational question. How does reality become capable of receiving either of these values? Suppose that an event is represented simply as E. The classical binary model implicitly assumes that legal reasoning consists of assigning one of two possible values: E1 plus E reitero 1 plus E plus 1, or E1 irritero 1 E minus 1, where plus 1 equal to legal plus 1 equal to legal plus 1 equal to legal minus 1 equal to illegal minus 1 equal to illegal minus 1 equal to illegal. At first sight, the model appears complete, yet it immediately encounters an anomaly. Consider the following event. Equal to a person is sitting on a bench. Equal to text, a person is sitting on a bench. Equal to a person is sitting on a bench. Before any legal reasoning begins, the event cannot meaningfully be assigned either value. It is not legal, it is not illegal. More precisely, neither proposition has yet become computable. This immediately creates a mathematical problem. If the binary model allows only two possible values, -1 + 1, -1 + 1, -1 + 1, this, though valid position within the model. The model therefore appears complete only because it begins after the decisive computational step has already occurred. The obvious question is therefore not whether legal reasoning is binary. The question is whether binary reasoning presupposes an earlier state that has never been explicitly modeled. 2. The first variable, the event. Having established that the binary distinction describes only the final state of legal classification, the next question is more elementary. What exactly is it that law classifies? The obvious answer might be facts. But facts do not arrive inside law already bearing legal meaning. Before a legal program is selected, even a factually dense situation may remain legally unmarked. Consider the following factual event. A civilian solicitor attends the controlled entrance area of a military site in her professional capacity. On a previous occasion, in materially similar circumstances, she had been present in the same type of controlled area as a solicitor, without any personal restriction being applied to her. On the later occasion, security personnel refuse to allow her to remain or proceed. They do not provide a written decision. They do not identify the legal basis of any personal restriction. They do not explain whether the refusal is temporary, security-based, administrative, procedural, or connected to any adverse marker in a security system. During the interaction with military police, the solicitor asks for an explanation. She asserts that, as a British citizen, she is entitled to know whether any decision has been made affecting her status, access, or treatment. The military police respond that she has no rights as a citizen. The solicitor remains in the controlled area and continues to ask what decision has been made about her and on what basis. Military police then treat her continued presence as non-compliance with site security instructions. They brief civilian police that she is under investigation and that her conduct concerns alleged breach of national security legislation, including the National Security Act and/or the Official Secrets Act. Civilian police attend and inform the solicitor that the matter concerns national security legislation, espionage, and alleged breach of the Official Secrets Act, National Security Act. At no point has the solicitor been given any prior notice of an adverse status, personal restriction, security marker, or decision prohibiting her presence. This is not a simple factual scene. It is dense with institutional conduct, legal language, security signaling, and competing claims of status. Yet it is still not legally classified. Let us define E equal to event, more precisely, E equal to E1, E2, E3, E11, where E1 equal to civilian solicitor attends controlled site entrance in professional capacity. E2 equal to previous comparable professional attendance occurred without restriction. E3 equal to continued presence is refused. E4 equal to no clear decision, notice, or legal basis is provided. E5 equal to solicitor requests explanation of any decision affecting her status. E6 equal to solicitor asserts citizen-based entitlement to know the decision. E7 equal to military police state that she has no rights as a citizen. E8 equal to military police treat continued presence as security non-compliance. E9 equal to military police investigation. E10 equal to national security legislation is invoked, including the National Security Act and/or Official Secrets Act. E11 equal to no prior notice of any adverse status, restriction, marker, or prohibitory decision has ever been given. At this stage, the event clearly exists, but its legal value has not yet been generated, so the only honest notation is LE equal to. The question mark matters. It does not mean that the event is neutral in the sense of being legally approved. Nor does it mean that the competing legal forces are perfectly balanced. It means something more basic. No legal program has yet been selected that can transform the factual event into a legal event. The event is factually dense but legally unmarked. Through one legal program, it may appear as a site security incident. Through another, it may appear as enforcement of an unnotified personal restriction. Through another, it may appear as a public law failure of notice, reason, status, and legality. Through another, it may raise questions of differential treatment. Through many other legal programs, it may produce no legal meaning at all. The mathematical problem is therefore not yet LE greater than 0 or LE less than 0. The first problem is LE equal to. This is where the binary model begins to fail. It can describe the final polarity of legal meaning, but it cannot yet explain how a factual event becomes capable of receiving that polarity. Not yet explain how a factual event becomes capable of receiving that polarity. 3. The missing variables. The previous section established an important result. A factual event can exist in considerable detail without yet possessing any computable legal value. The notation, LE equal to, therefore represents more than uncertainty. It represents an incomplete model. The immediate mathematical question becomes, how does a factual event become capable of legal evaluation? The classical binary model offers no intermediate operation. It assumes that an event can be classified directly as legal or illegal, yet the example above demonstrates that this assumption cannot be correct. The factual event remains identical. Nothing about the observable reality changes. Nevertheless, lawyers, judges, regulators, and public authorities may reach entirely different legal conclusions. If the event itself remains constant, then the source of variation must lie elsewhere. The model therefore requires additional variables. The first is the legal program. Let P equal to legal program. A legal program is a coherent interpretive framework through which the legal system processes a factual event. Examples include public law, national security law, equality law, contract law, company law. The legal program does not alter the factual event. It alters the questions that are asked about the event. It determines which facts become legally relevant, which are ignored, which legal principles are activated, and which normative objectives guide the analysis. The second variable is therefore required. I equal to legal interpretation. Legal interpretation is not the event itself. It is the meaning generated when a factual event is processed through a particular legal program. At this stage, the relationship can be expressed simply as E plus P, I. The factual event enters the legal program. The program produces an interpretation. Importantly, the same event may generate multiple interpretations if different legal programs are selected. The third variable naturally follows. Let L equal to legal valence. Legal valence represents the legal direction produced by the interpretation. At this stage of the analysis, it is not yet necessary to define how legal valence is calculated. It is sufficient to recognize that legal valence cannot arise directly from the event itself. It arises only after the event has been interpreted through a particular legal program. The developing model can therefore be expressed as E, P, I, L. This sequence is significantly different from the classical binary model. The binary distinction between legal and illegal no longer appears as the starting point of legal reasoning. Instead, it becomes the final stage of a much longer computational process. The remainder of this paper is concerned with understanding how that process operates. 4. Legal interpretation. The introduction of the legal program immediately changes the nature of the problem. The event itself has not changed. The legal program has. This raises an obvious question. What exactly does a legal program do? It does not create new facts. It does not alter reality. It does not change the chronological sequence of events. Instead, it performs something far more fundamental. It transforms a factual event into a legally meaningful representation of that event. This transformation is what this paper refers to as legal interpretation. Let I equal to legal interpretation. Legal interpretation should therefore not be understood as a subjective opinion or judicial discretion. It is the computational output produced when a factual event is processed through a particular legal program. The relationship may therefore be expressed as I equal to FP, E, where E equal to factual event, P equal to selected legal program, I equal to legal interpretation. The notation is important. The function does not generate a new event, nor does it alter the existing one. Instead, it generates a new representation of the same event. The physical reality remains constant. Its legal representation changes. This distinction explains why different legal programs produce different legal interpretations without requiring any disagreement about the underlying facts. For example, consider the event described in the previous section. A national security program may generate the following interpretation. The solicitor remained within a controlled security area after being instructed to leave and therefore failed to comply with site security measures. A public law program may generate a different interpretation. A public authority enforced an undisclosed administrative restriction without prior notification, reasons, or procedural fairness. An equality law program may produce yet another interpretation. The factual sequence raises the possibility of differential treatment requiring legal justification. A company law program may generate no interpretation of legal significance at all. The factual event has remained identical throughout. Only the interpretive function has changed. This observation has an important consequence. Legal disagreement is often described as disagreement about law or disagreement about facts. The present model suggests a different possibility. Very often, legal disagreement begins much earlier. It begins with the selection of the interpretive function itself. Different legal programs do not merely produce different legal conclusions. They produce different legal realities. The event remains constant. The legal world constructed around that event does not. 5. Legal valence. The introduction of legal interpretation immediately raises another question. If different legal programs generate different interpretations of the same factual event, how should those interpretations be evaluated? Interpretation alone cannot produce a legal conclusion. A further operation is required. Let L equal to legal valence. Legal valence represents the legal direction generated by a particular interpretation. Importantly, legal valence should not be understood as a binary label attached